I had a great pleasure and honor of introducing Kirk Ludwig, who is a professor in Indiana University in Bloomington. He's one of my favorite philosophers of this area, so this is a great honor. And he has published several volumes on important topics. He has written numerous articles. He has just recently he published 2 volumes on individual and collective action, and these 2 volumes will definitely provide food for thought for us for several decades to come. But more than these, even more than these great academic achievements, I appreciate everything that he has done to this community. He is the former president of the International Social Ontology Society. A few years ago, he organized the Collective Intentionality Conference in Bloomington, and that was a fantastic conference. And most importantly, he invited all of us to his home and threw a great party. So he's just a fantastic guy. So please give a big hand to Kirk Ludwig.
Thanks for that really generous introduction. I was given a choice between 2 mics. They were described as the Madonna mic and the Elvis mic, and it was kind of intimidating. You can see I chose the Madonna mic. And during the discussion, you'll be given the Elvis mic. So we might have called this talk Madonna versus the Elvises. We'll see how it goes. Okay. So the title of this talk is The Social Construction of Legal Norms. And of course, this comes with a thesis, which is that legal norms are socially constructed. And I don't think that thesis is very controversial, or at least it shouldn't be. But I think there's a lot of interest in trying to figure out what it comes to. What does it mean to say that the law, in some sense, is socially constructed and that legal norms are socially constructed? And so that's going to be the sort of program of the talk. Now, the idea of the talk was to take some work that I'd done on the nature of institutions in general, institutions in the organizational sense in particular, and try to apply it to the special case of the institutions of the law. So that's what I'm going to try to do. Now, institutions in the organizational sense I think of as being characterized in terms of a set of interlocking institutional roles which can be successively occupied by different agents. And this is what gives rise to the possibilities of institutions having what is called perpetual existence. That also is what gives institutions the tremendous power that they have, because we're born into institutions. We live our lives in institutions, and we die in institutions. We wouldn't understand the forms of life that we have without understanding the structure of the institutions within which we live them. And legal institutions are arguably the most important institutions for understanding this, because it is in the legal framework that almost every other institution that we participate in or interact with is defined. So we're going to try to understand in a little bit better the nature of legal institutions, and in the time I have, it's only going to be a little bit of progress, but I hope it is going to be some progress. Okay, before we get started on the work of the talk, there's one other thing that I want to do, and that is to thank the organizers, the organizing committee, and the program committee, which subsumes the organizing committee as well. First of all, a personal thank you, because they invited me and I have this opportunity to talk to you, and I'm really thrilled by it. But I thought we should all thank them as well as a group, because things have gone splendidly up to this point. And it's nice to thank people for a good job, and there's a lot of time between now and Saturday evening, and things could go horribly wrong. So if you will, join me in thanking the organizing and program committees. Okay, thanks very much. That's a high note. Now, let's see. I'm going to try to talk for about 45 minutes, so we have roughly the same amount of time for discussion, but I'll probably fail. But at some point, Raul's going to remind me, and we'll see how this goes. So first, a quick outline of the talk. So I want to do a little sort of introduction where I do some stage setting and say what my target is, and give you a little synopsis of the view, and then fill in the details as we go along. So there are going to be a number of ideas that I want to put on the table as part of the general theory of institutions, and then I want to apply those to the case of legal institutions. I'm going to talk about status functions and explain those in terms of constitutive rules. I'm going to introduce the notion of a status role, which is a particular type of status function, and that's going to be what I identify as an institutional role. So institutional roles are a certain type of status role. Then I want to talk about how the vocabulary rights and duties attaches to status roles. Where does the room come for the introduction of normative notions in connection with status roles? I was going to talk about desire-independent reasons, whether status roles generate them, but I decided I'm not going to have enough time for that. So it's on the slides, and it turns out to be on the handout, which I forgot to distribute. So we're going to start that right now. Okay. The handout just duplicates the slides, so you'll see the stuff about desire-independent reasons in there. Then what I want to do is introduce the notion of a proxy agent, which is a particular type of status role that turns out to be enormously important in understanding the structure of institutional agency, and will be important also for at least one point that I want to make about the law. And then I want to look at legal norms and the law's authority in the light of this story, and then say a little bit about a few old issues in the philosophy of law very briefly, something about distinction between primary and secondary rules, which H.L.L. Hart drew, and something about the debate between legal positivist and natural law theorist, and finally a little bit about how to distinguish the institution of law from other institutions which have a lot of similar features. Okay, so that's going to be the program of the talk. So let's get started. So what are norms? So I'm thinking of norms as characteristically stated in ought or should statements, and examples are things like you ought to obey a police officer's lawful orders, or you ought not to kill a moral agent for fun or profit, or if you want to be a lawyer, you ought to go to law school. And some of these are absolute, like the statement that you morally ought not to kill someone for fun or profit, and some are conditional, like the statement that if you want to be a lawyer, you ought to go to law school. Norms are, as I'm thinking of them, defined by a standard of evaluation of action, and different kinds of norms are defined by different standards, moral norms, legal norms, norms of etiquette, and so on. They're intended to guide action in relation to the standards, but the logical structure of talk of norms doesn't guarantee that anyone has any reason to be guided by the norms independently of accepting them as a kind of regulative ideal. So nothing about the logic of norm talk guarantees that we have reasons to obey any norms. There have to be an independent argument for that. So what are legal norms? So that's the question, and I'm going to think of this as sort of dividing into a number of different questions. What's the source of legal norms? What's the extent and nature of the authority they have over us? What sorts of reasons do they give us for actions? How are they grounded? What's the relation to other norms, like moral norms in particular? And, well, if I had more time, I would ask whether they generate desire-independent reasons for action. Okay, so quick synopsis of the sort of view. So norms are an invention, as is the legal system. It's something that we invent. It's a technology. It's a tremendously successful social technology. Legal norms apply in a legal system, and that's a type of institution. And we understand legal norms, this is the program of the talk, by subsuming them in a broader theory of institutions as interlocking status roles, which can be successfully occupied by different agents. The legal norms derive from, and this is a central idea of the talk, from rules which define status roles in a legal system. The role of the legal institution in general is to provide a framework for the maintenance of a civilization, organizing social and economic life in a group of agents and their successors. And the authority of the laws for its subjects derives from its officials being proxy agents for all of its subjects. Now, the characteristic structure of a legal system is generated by conceiving of it as an institutional group having proxy agents who are authorized to make policy for the group. And the rules governing the basic constitution of the group and the powers of the policy proxies determine the fundamental norms for the group. And the policies that the policy proxies promulgate determine further norms whose force derives from the fundamental norms. And so this gives a characterization of a structure of legal system. Other systems have similar structures, so something more needs to be said about what makes a system of this structure a legal system, and I'll say a little bit about that right at the end. Okay, so I am going to approach this by talking about what I'm going to call the atomic structure of institutions, and by that I have in mind what are the sort of smallest elements that we put together to construct institutions. And I want to talk about this from the point of view of their conceptual structure. So central to this will be the idea of a status function. Examples are being a pawn in a game of chess, or being a 10-euro note, or a 10-pound note, a passport, and so on. And I'm going to explain these in terms of a particular sort of constitutive rule. And among these, the constitutive rules, an example of constitutive rules are the rules of chess. They're also an example of a type of constitutive rule that generates a role for a status function. And I'll use that as an example in explaining it. Constitutive rules I'm going to, in turn, explain in terms of the concept of an essentially intentional activity type. And these come in two varieties. There are those that are defined by a goal that's pursued intentionally, like looking for your lost keys, and those that are defined in terms of a pattern of activity that has to be instantiated intentionally. And it's the latter sort of essentially intentional collective activity type that I'm going to use to explain the force of constitutive rules. Then I'm going to introduce the notion of a status role, which is a particular type of status function. Examples are being a senator, being a university president, or a university professor, being a student, and then whoops, what happened to that? Okay. Then I'm going to introduce the notion of a proxy agent, and examples of proxy agents are a spokesperson, a president, and the parliament. The proxy agent acts for a group, in a sense representing it, and I'm going to explain what that comes to in terms of a particular kind of status function attached to a person operating in an institutional context. Okay, so that is the list of sort of the fundamental concepts I want to use and explain, and we're going to start with status functions and constitutive rules. So the notion of a status function was introduced in John Searle's 1995 book, The Construction of Social Reality, in the following passage. The radical movement that gets us from such simple social facts as that we're sitting on a bench together or having a fist fight to such institutional facts as money, property, and marriage is the collective imposition of function on entities, which, unlike levers, benches, and cars, cannot perform the function solely by virtue of their physical structure. The key element, he says, in the move from the collective imposition of function to the creation of institutional facts is the imposition of a collectively recognized status to which a function is attached. That's where he really introduces the idea. It's a little bit unclear what that comes to, and I'll say how I think it should be understood. Since this is a special category of agentive functions, I will label these status functions. So I like the label, and I think Searle has identified a super important category of item in the social world, but it's a little bit unclear how to think about what he says about it here, and I'm going to understand a little bit differently. So he has this idea that a status, an object is given a status, and a function is attached to the status, and I don't think that really makes sense when you try to think it through. So on my view, it's really going to be something like the assignment of the function to the object gives it, at that instance, a status which enables it to perform its function, and you'll see how this gets spelled out in detail. So let's look into this. So an agentive function is just a function that's assigned relative to the practical interest of conscious agents. And then what's special about a status function is that it's an agentive function whose special feature is that objects can perform it only in virtue of, as Searle puts it, the collective acceptance that they are to have that function. And so the question is, why do status functions have this special feature? Why are they the sort of function that can be performed only if a group of agents collectively accept that it has that function? So I'm going to explain that. Okay, so how are we going to do this? I want to talk a little bit about constitutive rules because this will be the background to it. So constitutive rules are typically contrasted with regulative rules. Constitutive rules are the sort of rule that the following of which at least partially constitutes the type of activity which it governs. And if there weren't constitutive rules, there couldn't be that type of activity in a community at all. And regulative rules are rules that govern a type of activity which could exist independently of the rules being followed. So examples are things like traffic laws. There could be traffic without being traffic laws. It'd be more chaotic, but it could occur. And then another example is Robert's Rules of Order, which is used to govern meetings, but meetings can occur without Robert's Rules of Order being followed. Chess rules are a contrast to that, so there wouldn't be such a thing as chess if there weren't rules for chess. And there are different views about how closely you have to follow the rules, but it's certainly true that following the rules, two people following the rules, does constitute the play of a game of chess. Okay, so one thing is that to notice is the constitutive rules govern essentially intentional activity patterns. So chess is a good example of this. And if you think about it, you can see that there's a way of extracting from the rules inscription of a pattern of activity which could occur independently of whether or not it fell under the concept, for example, of chess. And what we get, once we see that, we can see that you can analyze the concept of these types of activities in terms of two components. One is a neutral description of an activity pattern, and the other is the requirement that the activity pattern be instantiated intentionally. And the idea of rules is the idea of a conception of the game or the pattern as described by a series of prescriptions for actions for the agents, which are followed intentionally. So we get a sort of two-component view of the types of activities constitutive rules govern. And what this also shows us is that the sense in which the rules are constitutive of the activity just turns out to hinge on the definition of the activity requiring that the activity pattern be instantiated intentionally. So there's actually nothing deep about the concept of constitutive rule. It's entirely relative to the type of activity that they govern. And if this is right, then any activity pattern is such that it could be used to generate an activity type relative to which there are constitutive rules. And an easy test of this is just to think any set of regulative rules is such that, well, if this is right, there should be an activity type relative to which there are constitutive rules. So is that right? Well, what about Robert's Rules of Order? Meetings can occur without Robert's Rules of Order being followed, but let me define a parliamentary meeting as a meeting which is governed by Robert's Rules of Order. Then, of course, Robert's Rules of Order are constitutive rules for the conduct of a parliamentary meeting. Okay. So, the weight of the distinction between regulative and constitutive doesn't rest on the content of the rules or anything about them. It rests on the type of activity that they are thought of in connection with. Okay. So how does this help us to understand what's going on with status functions? So here's the idea. Status functions have a role in an essentially intentional joint activity type that's governed by constitutive rules. But the constitutive rules define activities involving items that play a role in them without specifying what particular things are to fill those roles. So in effect, the constitutive rules define role concepts, or they define functional roles for things. But they don't say, if you're going to engage in activity, what are the things that play the roles? So that presents a kind of coordination problem for those who intend to engage in the activity. And to solve the coordination problem, they have to coordinate on the same items for the roles. And that's a form of collective acceptance of those items as fulfilling those roles. And it's why those items can fulfill those roles only if it's collectively accepted in a certain sense that they have them. Okay. Now, let's take an example. So take a pawn in the play of chess. What makes a particular item a pawn in the play of chess? So to be a pawn is to be subject to the pawn rules, and so the players must accept the item as subject to those rules. The rules do not uniquely determine what's supposed to be treated as subject to the pawn rules. They describe a role for an object in a game. So the players have to agree or settle on treating that object as subject to the pawn rules. And if they don't settle on the same thing, it's not going to work. So being a pawn is a function an item can perform only if the participants collectively accept, in this sense, that it's to perform that function. Okay. Now, this also gives us some insight into what the notion of, how the notion of collective acceptance should be understood. So Searle, when he talks about this, seems to treat it as something like an attitude-like belief. So it's supposed to have mind-to-world direction of fit. And that's part of what seems puzzling about the way he talks about it. But I think that really gets it exactly backwards. So it could be that we all believe some object has a certain function, right? So we might think an object has a certain unit, the function of having a certain unit of monetary value. But if none of us are willing to act in accordance with that belief, it doesn't function as an object that has a certain unit of monetary value. So what's really important is that we're committed to treating the object in the right way, and that commitment comes to our having appropriate conditional participatory intentions with respect to anyone we might want to engage in the relevant activity with. So what it really means is that what constitutes collective acceptance is there being a community in which there are enough people who have appropriate conditional we intentions, participatory intentions, with respect to collective intentional activity that are directed on those objects. Okay, so that's what collective acceptance comes to. And so instead of it being mind-to-world direction of fit, it's world-to-mind direction of fit that constitutes objects having status functions. Okay, now you might think, well, is this really right? After all, there's an image of a pawn there. That's kind of standard shape. Don't we recognize pieces in chess by their shapes? If you Google chess sets, you'll find out that there are just an enormous variety of different things that people have thought of as chess sets. So one of my favorite examples, I really need 2 pointers here so I can do both of these, but yeah, you can imagine one over here. So, the beer can, I think that's shaving cream, there's a tube of toothpaste, anything can be used as chess pieces. It just matters, all that matters is we coordinate on the same things. And you can also see, even from this, the boards can vary a lot. And one of my favorite examples is, they don't have to be flat. You can see, that's Braille chess. Colors don't matter, squares don't matter. All that matters is there's a certain structure, which has the structure of a board, and pieces which can be distinguished into 2 sets, and each of which involves items of the same sort, and so on. Okay, it's a tremendously flexible and powerful idea, defining functional roles for things in social transactions, and the flexibility is just the limits of our imagination, really. Okay, and one extension of this has to do with what I'm going to be calling a status role. So status roles, it's really a brilliant invention. Status roles are a certain sort of status function. They're assigned to agents, and the key thing, it's not like treating someone as a pawn, which you could do, but they're assigned to agents, and their functions are defined in part in terms of the agents to whom they're assigned exercising their agency self-consciously in the role. So that's part of the definition of the function, that they should self-consciously exercise their agency in the performance of the role. And the functions are defined in relation to interactions with others in virtue of their status roles. Okay, so it's already from the very beginning a kind of institutional notion. Examples for individuals are spokesperson, president, prime minister, professor, clerk, club treasurer, defendant, prisoner of war, and so on. Groups can have status roles as well: Parliament, the Supreme Court, the United Nations, the Intergovernmental Panel on Climate Change, hierarchies of groups, and so on. So what do status roles have in common? Well, at least some of these things. In the relevant community, it's collectively accepted that those possessing status roles are to give directions or permissions to others in virtue of their status roles, or to accept them in virtue of the relation between the status roles, to play certain roles in essentially intentional joint activities, where I'm just leaving open what kind of role that is, and we'll get some examples as we go on, on certain conditions obtaining or at their discretion or upon exercise of their judgment about certain matters that all parties to the arrangements are to act in conformity with. And that's in part what the power of status roles resides in, this agreement that people get to do things and others are going to conform to decisions or directions and so on that they make. That's why armies work. What are the status role powers that arise from this? The powers agents have in virtue of their status roles include directing or giving permissions to others. Again, think about the hierarchy of ranks in the army. You get to give directions to those in the chain of command of lower rank, and you accept them from people who are in the chain of command at a higher rank. You can exercise rights, which is a matter of others having, well, certain kinds of duties with respect to you. You can make findings that have an official status that others must conform their behavior to. You can issue rules, which are generalized directives, and you can confer status roles on others or status functions on things, which is another powerful extension of the idea. So I want to make a distinction between two kinds of status roles, which nothing I've said so far distinguishes between. On the one hand, agent status roles, and on the other, patient status roles. So an example of an agent status role is being a judge or professor, and of a patient status role being a prisoner of war. And the key distinction between them is that in the case of the agent status roles, the person who possesses the role is supposed to accept, be party to the collective acceptance by which he has the role. And for a patient status role, that's not so. So a POW doesn't have to be a party to the collective acceptance by which the role is imposed on him. Nonetheless, there is provision for him to express his agent in that role. But the motivation doesn't come from being part of the collective acceptance, but from external coercive measures that are imposed upon them. I also want to make a distinction between what I'm going to call pure status roles and sort of mixed status roles. So some roles are what I'm going to call agent-patient status roles. So acceptance is presumed, but provision is made if acceptance is not, if acceptance is absent. So the criminal defendant, for example, has a role to play in a trial, but if he or she refuses to play that role, it doesn't matter. The trial goes on. We have provisions for what to do to enforce cooperation to the extent possible. And adult citizens are, in some respects, a little bit like this because you have the status, and you might not, accept citizenship, but that doesn't matter from the point of view of the nation in which you have citizenship, and we'll come back to this. Okay, so that's an important category. A lot of this, there being these sort of mixed roles has to do with the, the sort of theoretical conception of the ideal institutional arrangements that runs into the real-world fact that people don't always participate in the way they're supposed to in these arrangements. And this gives rise to different ways of thinking about entry and exit conditions to status roles. So I'm going to distinguish between what I'm going to call substantive acceptance of a status role and formal acceptance of a status role. Substantive acceptance, one thing you could think of conceptually as an entry role for certain kinds of entry condition for certain kinds of status roles is to just be party to collective acceptance. And in informal context, that might actually be a necessary condition for having the role. But when you get any kind of more complex organization or institutional structures, which we want to be stable over time, it's going to be important that we can continue to treat somebody as in that role and make provisions for what to do, even if the person signals acceptance but isn't sincere, or signals acceptance is sincere but later, decides that he's not going to be party to the arrangements. So that's what I'm going to call formal acceptance. That's signaling that you're party to collective acceptance, but you don't actually have to be sincere. You're going to get it if you do the signaling. So if you sign a contract to take a job, that's formal acceptance. And a lot of legal designations have that character. Then there are some sort of hybrid categories, and citizenship is an important example of this. So they can be assigned with and without formal acceptance. Most people are citizens by birthright, but of course you could be a naturalized citizen, and that involves meeting certain conditions, residency for a certain time, maybe passing a test, and then swearing an oath, and that's a formal acceptance of citizenship. Okay. Now, exit conditions for formal acceptance and even the hybrid categories often require more than you're just deciding you don't want to go along with it, and others have to relinquish their collective acceptance of your having the role, and very often there are formal conditions for this. And formal, status roles that involve formal acceptance are by their nature agent-patient roles, and the hybrid cases can be both pure patient and agent-patient roles. If you're prior to your majority, you're a citizen in virtue of birthright, that's a pure patient role. Okay. Okay, so now I think this puts us in a position to think about the way in which the vocabulary of rights and duties gets purchased on occupancy and status roles. Okay, so basic idea is just that in the nature of the case, there's always a possibility of a gap between the design function of a status role and the performance of the agent who has it. And I'm thinking primarily here of agent or agent-patient status roles. There can be failures of competence or performance, and so in that way you can fall off from the design function. But there can also be failures due to lack of commitment or even an intent to subvert the role. Okay, so in these cases we get a gap between how you're supposed to, in terms of the design function, behave in the role and how you might actually do so. And this is characteristically the role of talk of rights and duties, to identify a kind of regulative ideal which you can fall short of. Otherwise, there'd be no point to talking in this way. Okay. So this is what I want to suggest provides scope for the use of the language of rights and duties. The design function serves as standard evaluation for the person who possesses the role. So role occupants have rights against others in virtue of their role responsibilities with respect to them in virtue of their status roles, and they have duties or responsibilities with respect to performance of functions in the role in relation to others in virtue of the others' status roles. So what does this say about the relation between role responsibilities and moral responsibilities? If this is where we can ground the talk of rights and responsibilities in connection with status roles. Well, I think it's pretty clear that they're just completely independent notions, okay? And one way this comes out is clearly for patient status roles, like being a POW, there's just no moral duties that they generate to behave in accordance with the design function. It's somebody else's decision to impose this category on you that can give you no moral duties to perform in accordance with the design function. And in the case of agent status roles, well, it's clear that the design role may itself involve forms of behavior which are morally prescribed. So, the official torturer who's supposed to extract information from someone's political opponents, or the official assassin, their design function, the design function of those roles require them to do things which are morally prescribed. So you couldn't think that the role responsibilities were ipso facto moral responsibilities. There can, of course, be connections between moral responsibilities and role responsibilities. They might arise from a kind of promissory agreement or contract to carry out the role responsibilities that generates a directed duty to do so. It might come from generating expectations once you accept a role, a performance which others rely on and would be disadvantaged if you didn't perform. Or there could be antecedent moral duties to accept and perform in the role. But all of these ways in which the role responsibilities might generate moral responsibilities are due to there being independent moral principles which are applied to the context in which you accept the role. But the concept of role responsibilities and rights themselves are not moral responsibilities and rights. They're completely independent of that. They are, in the sense which I've characterized, just socially constructed notions. Okay. This is what I'm going to skip. This is me skipping it. Okay. Now, proxy agents. This is the last little bit before I turn to thinking a little bit about the law. So, what is proxy agency? In proxy agency, what one agent does counts as another agent or group doing something. That's the characteristic feature of proxy agency. So a paradigmatic example, and this is one I'll develop, is the spokesperson. It's a particularly clear case of this, who in speaking in her role, delivering a message that's been sanctioned by a group or an individual, performs an act which counts as her principles, for example, announcing something. Okay. So other examples are the United States declaring war when Congress passes a declaration of war, a corporation filing for bankruptcy when its lawyers file papers, a university awarding a degree by a clerk approving paperwork. That's how it works at my university. Someone with a power of attorney signing for me at closing when I'm selling a house. So that person putting his or her signature on a document makes it the case that I sold the house. Okay. So how is proxy agency possible? The proxy agent is a status role. It's a role in a transaction between variously individuals and groups. The proxy agent's actions, in virtue of that, have a status function or confer on things a status function in that transaction that requires the proxy agent to be authorized by the group for that purpose. So that's really the mechanism by which the principal expresses his or her agency through the proxy. The authorization consists simply in the assignment by the group, or you could have a spokesperson as an individual, but I'll concentrate on the group case. The assignment by the group of the status role to the agent, which is realized in the group's collective acceptance of the agent as having that role. Typically, the proxy agent is also party to the collective acceptance and often a part of the group. Okay, so the basic idea is sort of two things. When the proxy agent does something that counts as the group's doing something, it's subsuming what the agent does under a description that points back to the expression of the agent of the group through the assignment to the proxy of a role in a transaction with other groups. And so the description, the relevant description, doesn't really pick out just the act of the agent, but it picks out the act of the group, which is expressed through the agent. So that's the basic idea. Now, let's look at this in the case of the spokesperson, and I'm going to do this with this diagram. So pointing to both of these things. So first of all, there's this idea that we're trying to get at, which is something like a group announcement. What is the role of group announcement? Basically, what you want to do as a group is to express to some audience a commitment to act as a group in accordance with some proposition or some content. Okay, and the question is, how do you do that? Okay, well, groups aren't persons. At least not all groups are persons, and certainly even small groups can have spokespersons. So it's something a little bit distinct from what we do as individuals, but it's analogous to it. Okay. There are a lot of different ways you could do this. You could have each member of the group, pronounce one word in a message, but that gets kind of awkward once the group gets large and the audiences get large and so on. So one way of doing it is to say, well, look, we already have this device of individuals communicating with others. Let's just designate an individual to be a representative in the relevant sense of the group who will do the production of a speech act with a certain content, which we sanction. Then we want to get other groups in on this so they understand what the mechanism is. And in virtue of that, you're going to get something that works. So there's going to be a kind of intergroup convention, agreement on conventions for group announcement, which can be specified functionally independent of the spokesperson. And the spokesperson is a particular device for doing that, which involves the announcing group. This is the way the mechanism works, authorizing someone, appointing, authorizing someone as a spokesperson or a representative, which is a status role, which enables that person to convey on a speech act he or she performs in the role the status function of being a group announcement. And that status function plays a role in a social transaction between the audience and the announcing group. And it's this intra-group agreement on the spokesperson message, which is the mechanism through which the group members are constituent agents of the announcement itself. Okay, so that's how it works in the case of the spokesperson, and you can see that that works in general. Now, Raul just flashed a sign at me that said 5 minutes, and I want you to know that's a regulative rule. That's not a constitutive rule. So if the talk goes on past 5 minutes, it's still a talk. But I just violated a norm of some sort. I'm going to try not to violate it too badly. I think we're actually in a position now, finally, to talk about legal norms and the law's authority. So maybe I'll speed up just a little bit. Okay, so status roles and legal norms. Here's the basic idea. We're just going to apply this. Legal classifications under which we fall, by and large, are status role classifications. They specify status roles. Okay. And legal norms are defined relative to status role design functions. Okay. In effect, the laws define the status roles. And this means, of course, for the category of citizen, the status role is constantly being redefined as laws are changed, but that's fine. Status roles are realized in agents by the collective acceptance of a large enough community for them to function largely in accordance with the design roles, and hence they are socially constructed. So legal norms are socially constructed and internal to the design functions of the status roles to which they attach. So there's the payoff. That's the sense in which legal norms are socially constructed, exactly the same sense in which the norms attaching to any status role are socially constructed. And the authority of the legal norms derives from collectively accepting the network of status roles defining the legal system in which we participate. And I'm going to say a little bit more about that. So it's standard to distinguish between legal officials and their subjects, or the subjects of the law. And legal officials come in sort of three varieties. There are those who make law, legislators. There's those who decide its application, judges, and there are those who are its enforcers, who bring before the judges relevant individuals and then impose sanctions or punishments for violations. Now, the legal system also has its proper subjects, and those are citizens, both those prior to the majority and those after reaching majority, as well as permanent residents and transients and visitors in the territory that the law governs. Now, the citizens and permanent residents, those who are supposed to be sort of self-conscious citizens, they occupy agent-patient roles. Okay. And one thing I want to, and so do, for that matter, the legislatures, judges, and enforcers. One thing I want to emphasize is that, properly understood, the legal system, since it includes as status roles as citizens, and those are agent-patient roles, should be conceived of as involving a relation in which the citizens, after reaching majority, the participant citizens, in a little more fine-grained sense, stand in the relation of authorizers in a very general sense of legal officials. So the legal officials should be conceived of as proxy agents for the citizens. Now, what do I mean by the authorization relation here? Well, I don't mean that they formally authorize the legal officials. There are mechanisms for that. But by collectively accepting them, they are giving a kind of constitutive endorsement of the system. And if there weren't enough people who did this, there just wouldn't be the reality of the system of legal officials. Okay. And one important thing about this way of conceptualizing it, where the legal system is not just realized, as in the Hartian tradition, in the legal officials, is that it enables us to explain why citizens aren't really in the position of POWs with respect to the legal system, because they are participants in the collective acceptance by which the system is maintained. And if you didn't have that in there, you couldn't distinguish citizens from prisoners of war. the only reasons they would have to obey the laws would be coercive measures. So if we think of about the legal officials and participatory citizens, the idea is that the participatory citizens, in a sense, this general sense, authorize legal officials, and it's in virtue of that that the legal officials have authority over the participatory citizens, and so that really is the source of the law's authority. Okay. Now, what kind of authority is that? So let me distinguish between three notions of authority. Definitional authority applies when there are subjects to it simply in virtue of a status role to which they are not a party. Internal authority applies when the subjects to it have reason to comply that's not derived from the threat of sanctions. If they do not, so that would be they're collectively accepting the roles. And external authority applies when subjects to it have reason to comply only because of the threat of sanctions if they do not. So I want to say that laws have internal authority for participatory citizens because of the authority of the laws over them derived from their being party to the collective acceptance by which legal officials have their functions. Okay. So that doesn't give the laws of authority a lot of backing, but it nonetheless is constitutive, if I'm right, of the existence of a legal system, that there is this relation between the legal officials and their subjects. Okay, so quick look at a couple of issues in light of. So Hart's distinction between primary and secondary rules. So primary rules are the ordinary laws, and secondary rules are rules about rules. Rules of recognition, what counts as law, rules of adjudication, how it's applied properly, and rules of modification, how the law is introduced and changed. So on the current view, secondary rules derive from rules for status roles for legal officials in administering the legal system. Okay, so they're just derived from the design function. And while it's customary to say that it's a social practice among the legal officials that constitutes the legal system, that's not fine-grained enough. So the view that it really follows from the definition of a set of interlocking status roles is a kind of social practice or social custom view, but it's much more fine-grained. They're constitutive rules, defining roles for a large enough community. They're constitutive rules defining roles that a large enough community has to collectively accept as occupied by a designated set of agents for the legal system to be realized. Okay, so it's a very particular type of social custom or social practice. So what about implications for the debate between legal positivism and natural law theory? This is clearly a legal positivist position. It doesn't give any special status to moral principles in our understanding of what counts as a legal system. So legal norms are purely socially constructed. They're not per se moral norms. This does leave scope for morality in legal systems. So they may de facto promote moral goods. They may be designed with moral goals in mind, but it's just not definitional. Legal norms may mention moral considerations. There's nothing that rules that out. And judges may rely on moral considerations, fairness, for example, in ruling in certain cases where maybe the law gives out and discretion is required. This could even be internal to the design of the role or just a matter of practice. So all those things are possible, but the concept of a legal norm itself doesn't have any connection, any intrinsic connection with morality. Okay, one final thing, and then I'll stop. Okay, that was my official instruction, so now I am in violation of a norm. What's special about the institution, about law as an institution? So if any of you were at the Social Ontology conference in Boston last year and went to Scott Shapiro's talk, you may remember that he was thinking that the only way you could distinguish legal institutions from, similar kinds of institutions in the mafia was by adverting to the moral purpose of the law. And he dismissed a certain kind of move you might make there, which is say, well, legal systems are those systems that promulgate policies which are supposed to take priority over all other kind of policies in a territory. And the worry was that that rules out things like, federal laws, state laws, county, city laws, and so on. And I thought that idea was really on the right track, and you just need to spell it out in the right way. So I want to have a go at that, since I've just said that legal systems don't have any constitutive connection with morality. So here's the idea. It's really just a recursive definition based on this idea that laws take priority over a territory. A legal system, L, is an institution that makes provisions for a component institution to make rules, a component institution to determine their application, and maybe optionally, but typically a component institution that enforces them, where the rules of L have authority over every agent in a designated territory. They have authority over all who meet certain conditions, for example, birthright or residency, many of whom participate in it, and take priority over rules and policy issued by other institutions within the territory, and this is the recursive clause, or are recognized by a legal system, L+, itself recognized by L, that governs a territory that subsumes L's territory as taking priority over all other rules and policies issued by other institutions within the territory, accepting those of the subsuming system of law. So this is just to say, if you think about the structure of legal systems in the United States, there's federal law, which takes precedent over state law. But of course, it recognizes state laws taking precedent within the states over all other institutional rules, accepting the federal government's rules. And state law recognizes the federal government's laws as taking precedence over them, and so on down the hierarchy. So that's an easy way to include more limited systems of lawmaking bodies within a system of lawmaking bodies that takes priority over all other social policies. It's only if they're recognized in this way that they're going to count as legal systems. That rules out the mafia, it rules out the church, and so on. Okay, so in conclusion, and still in violation of the norm to have stopped a few minutes ago, let me say what I think are some advantages of this view. It grounds law in large-scale collective intentional activity, vindicating, giving precise content to the social fact theory of legal norms and legal systems. It exhibits legal institutions as continuous with other institutions and not sui generis. It explains legal norms in the same way as norms attaching to status roles in general, and that's clearly desirable. It explains the requirement that laws be general because they attach to status roles, right, which are a type under which people are subsumed. It's flexible enough to encompass as wide a range of rules as may govern, guide, restrict, or promote behavior in the assignments of powers, rights, duties, and permissions. And it explains why law should be written so that it's acceptable to its core subjects, since they are party to the collective acceptance by which legal officials have their roles, and in virtue of which they're representatives of the law's core subjects. Thank you.
Okay, thank you very much, Kirk. And then we will go for discussion. We have 20 minutes for discussion. And I've given the instruction not to address people by their names, which is very convenient for me because I'm a Finn and we usually don't do that anyway. So I'm just going to pretend that I don't know any of you. So please raise your hand, and when I give you the turn to speak, please introduce yourself and tell your name. First over there in the back. Yes. Could you please tell your name? Okay. Microphone.
Seamus Miller. Hi, Kirk.
Hi, Seamus.
Yeah, I'm just a bit puzzled by the relationship between moral norms, moral rights and so on, and institutional rights and duties on renewal, including institutional authority in particular on your account. So on the Serlian story, he basically says, if I understood him correctly, he's got a collective acceptance account along similar lines to yours, that moral rights and duties such as, for example, the right, which we would typically regard as natural, say the right not to be tortured or something, are themselves socially constructed, whereas in your view, as I've understood you today, that's not the case. So morality is sharply contrasted with institutional rights and duties. Okay, so what I don't quite see is how you get from ordinary empirical factual behaviour to institutional rights and duties. And the reason I don't understand that is because, let me give you an example. So supposing a vicious group takes over a community and terrorises everyone in the community and subdivides the community into sub-communities for the purposes of exercising power over this community into the future. And suppose that group is simply interested in getting the community to produce drugs so they can sell them for profit and so on and so forth. Now, there's a bunch of regularities in place. Everyone does what they're told. People turn up and perform their, as it were, their function, in terms of mixing drugs or whatever their particular assigned task is. But the members of the community would say, well, I'm just doing this because there's a gun at my head, I have to do it. I don't accept their authority in the sense of, even in the sense of institutional authority. It's just that I've got no choice in the matter. And you say, when the drug enforcer comes along, I don't say he's like a police officer, he has institutional rights and duties. He's just a guy with a gun and pointing at my head, I guess carry on and perform the task. So it seems to me that we would want to, at least I would want to, draw a pretty sharp distinction between institutional authority, institutional rights and duties, and that kind of arrangement. But I don't see any space to do that on your account.
Okay, well, so let me see if I have the challenge down correctly. So we can imagine an arrangement in which there are a group of people who themselves form a kind of institution and they sort of terrorize another group for various purposes, right? And there are sort of enforcement mechanisms to ensure behavior in the subject group. And and then is the question, how do I make sense of why it is that the subject members don't have rights and responsibilities?
This is the total community. These people have taken the thing over, right? They're not, so they have the terrorising group, as it were, own this, think of ISIS or something, own this territory. They're the only regularities in place, the ones they want, they're all enforced. Each of the membership of the terrorising group and the ordinary residents that have roles, namely to facilitate the industry of these people running the place. There is no other law and authority in this area, right? So we have roles, we have functions, we have a power system, a hierarchy. It's all done in terms of physical coercion, although the members of the terrorising group themselves, of course, have an interest in this because they make a lot of money from the drugs and so on. But that's it. Why isn't that a legal system on your account?
Yeah, okay, good. So, so when I was discussing a sort of traditional conception of the role of legal officials, where the legal system was being instantiated by the legal officials themselves, I did say I thought that missed something really important about our concept of law, and that was that there was the subject of the law themselves were party to the collective acceptance. Now, one thing about the situation you've described is those who are, subject to the people who control the power structures are not parties to the collective acceptance by which they have their positions in that institutional structure. And so that doesn't count for that reason, in my view, as the law. Now, it puts those people somewhat in the position of people in a prisoner of war camp or in a concentration camp, where there are rules that are assigned to them to be followed, and the measures to make sure they follow them are purely coercive. Now, within the group that has power over them, I would say there can be things like laws, policies that are promulgated and that they all participate in accepting and so on. But the people who are then subject to them by coercive measures are not parties to that. And so they don't regard those as laws that they're subject to.
We have very many questions and very little time, so I think we should move on and continue.
I think the pressure goes back on the notion of collective acceptance at that point. It doesn't look like mere compliance with procedure. Anyway.
Yeah, okay, we'll come back to this.
Okay, 3 rows this way. I think you wanted to. Yes. But please be succinct because we don't have much.
Sort of in the same ballpark, so better move on.
Okay, fine. Then, all right there, yes. Yes.
Thank you very much. So my question is about, you talked about this possibility of a gap between the design function of the role and the performance by the agent who fills the role. And I'd like to know more about how we determine what the design function is such that we can make that kind of judgment. So suppose we have a president who is a white supremacist. When do we say this individual is failing to live up to the design function of the role? And when do we say, oh, we have a white supremacist state functioning like white supremacist states function?
Yeah, okay, good question.
Could you please tell your name still?
I'm so sorry, Catherine Jenkins.
Yes, thank
Okay,
you.
thank you. So any set of rules that in a community are promulgated to guide behavior are apt to not be super precise. There's always going to be some vagueness. This is true about rules for the use of language, of course. So there's going to be some vagueness involved. Now, in the case of, I mean, it's always good to focus on a particular case. Let's take just an example, the presidency of the United States. Okay. Now, there's a Constitution, and it lays out some duties and responsibilities and so on. Those are themselves stated in a form that's a little bit vague. And then there's, case history involving the Supreme Court and so on. And so that's the sum total of the things we can actually look at to decide whether or not the institutional role is violated. And in the nature of the law in general, it's kind of open texture, right? And so it keeps getting more refined as, cases come up and tested. So sometimes we get, relatively clear violations. Other times it's hard to tell. So far as I can see, racist ideologies aren't incompatible with the United States Constitution since they were built in from the beginning. So I wouldn't count that itself as a violation of role responsibilities, though it might be, a violation of all sorts of other responsibilities and sorts of expectations in the culture that are independent of the role definition. Does that help? Okay.
All right, we have one question over there on that side, yes.
Yeah, thanks for the presentation. I'm Visa Gorki from the Helsinki Law Faculty. I should mention that I think racist ideologies are sort of incompatible with the US Constitution as it's now, after the 15th Amendment, I think. But actually I want to go a little bit back to and sort of defend Hart as opposed to your theory that, for Hart, there's the groups of officials and citizens as well. Or I guess we should say subjects at this point, whereas I think you in the earlier slide make this distinction between sort of citizens who are rich majority and the other groups. And I think that's probably a very nice way of putting forward democratic theory, but it's not really a general theory of law in that sense, because you don't really need to have citizens or anything of the like in order to have a legal system. And I think if you're a positivist, then you should allow for the fact that you can have a legal system where you have just let's say a tiny minority who dominate the rest, and the rest really just go along with the minority. And I guess you sort of allow for that maybe in some other slide that you had, but not earlier. So for instance, we can have, say, the Mongols dominating northern India almost a millennium back. I'm not sure the sort of lower caste really accepted that rule. Maybe at some point they started accepting the rules, but certainly they went along with it and they played by the rules. And I think that's enough to constitute a legal system. It was their law as well because they had to comply. So how would you respond to that?
Yeah. Well, so I want to admit that we can draw a lot of distinctions between different kinds of institutional arrangements, and there can be institutional arrangements in which there's a power structure, and they really do conceive of subjects to rules as something like prisoners of war, and the mechanisms are intended to be that enforce compliance are intended to be coercive in character, and they're not conceived of as buying into the system. Okay, there can also be systems that start out with the ideology of a sort of representative system. It doesn't have to be democracy to have the thought that the subject could have buy-in. That could be independent of that. But there could be systems that are taken over by groups that then convert them into something that is a sort of mockery of what they are intended to be. And then there's a question, well, what are we going to call a legal system? Okay, now, maybe a little, there might be a sort of ordinary language question about, what is the practice with respect to the notion of legal system? And there's a real question about the practice there. But there's also, in a certain sense, a little bit verbal, because we can mark all these distinctions and understand what they're keeping track of. Now, I was thinking about it being important to think about a genuine legal system that we could make sense of its having something like genuine authority over its subjects. So that was what was motivating the way I was dividing up the territory. But I don't want to deny that there are the kinds of systems that you're talking about. And I don't want to struggle too much over the use of the word legal system in connection with that.
Thank you.
Right, then you, yes.
Thank you very much. I'm Arve Särkälä. I was wondering how vastly is the concept of social construction in your view? I was wondering, for instance, let's take legal norm like the freedom to roam in many European countries, so-called everyman's right. It was very much established. It was a rule that evolved. It's difficult to see to me how it was socially constructed in the same way as the examples for legal norms that you gave. So what would be the difference between saying that the freedom to roam is a legal norm that has been socially constructed from saying that it was ex post facto formalized by legal practices?
Yeah, okay, good. So, so there are formal procedures for introducing rules where the people given the authority to introduce them, it's collectively accepted they have it, and the introduction of it then requires others to conform with it. And then there could be procedures, of course, for challenging it and so on. But the idea of the social construction of roles itself goes back to the idea that it's collectively accepted in a large enough community to give it reality. And that can be an informal process as well as a formal process. So the central thought behind the idea that these rules are socially constructed is the attached to status roles. And the reality of the status roles comes to there being enough people who collectively accept individuals and having those status roles to make it effective in the way that people treat them in virtue of that. Does that help? And then it can be, that's a way of seeing how it can be socially constructed and then formally endorsed afterwards.
Okay, and then 2 rows back from that person.
Whoever that is, right?
Yeah, my name is Frank Hendricks. Thanks very much for your talk. I have a remark and a question. Well, I guess it's 2 questions. But the first one is really short. So you distinguish between roles and functions, but it seems that the notion of function is not doing any work independently of the role. I've argued with respect to Searle's framework that the notion of function is redundant as he uses it. So I'm wondering whether that's the case for you as well. that seems to be rather counterintuitive. So I was wondering whether you were willing to go that far as well, or whether distinction plays another role in your framework. I was a bit puzzled because at first you set up the distinction as if it is as strong as an Searle, and then you claimed, well, you know, constitutive only means that behavior, the activity that is governed by the rule is instantiated intentionally, and I suppose that is necessarily the case. And that any activity can be construed in that way, but then traffic can also be explicated in terms of constitutive rules. So then you have an answer to the first part of the question, but yeah, I'm a bit confused there.
Okay, well, so let's see. The first question is the notion of function doing any work in my story? Is that right?
Independently of role.
Independently of role. And let's see, the second question, take traffic as an example. Could you restate what the question is precisely about that?
Well, the core question is whether you would go along with Searle's claim that traffic is not an institution because it is not supported by rules that are constitutive.
Ah, I see. Yeah. Okay, good. Yeah, so what is the notion of function? What's the work the notion of function doing when I'm talking about status function? Well, it really comes down to the idea that grounds this claim that something can perform its role in a social transaction only in virtue of there being a collective acceptance that it has it. And I explain that in terms of constitutive rules that define a functional role for an item in a social transaction without specifying what thing has the role. So that's where the notion of function comes from on my story. And that transfers to status roles as well. Now, in the case of thinking about traffic as an institution, well, what is traffic in the first place? I think it covers probably a lot of different things, and some of the things it covers might also be institutions or conducted in institutional context as well. I don't know, would it apply to, it's the Serengeti, there's a herd of impalas, and there's a herd of kudu, and they're at the water stream, and it's a lot of traffic there, If it applies to that, then traffic isn't constitutively an institutional notion, I think. Traffic on the streets, of course, takes place in an institutional context, so that form of traffic you can't disentangle from institutions, so I'm okay with that. But that's the context in which the traffic takes place, I think, not the concept of traffic itself. And let's see, okay, so that's...
All right, does anyone have a snappy question that allows a short answer? There. Yes, you.
Is the concept that creates authority hypothetical based on good reasons, or is it real?
Microphone.
And could you still please state your name?
Is your notion of consent hypothetical based on good reasons, as you said in some slide, or is it just factual consent, which seems to be more the positivistic line?
I'm sorry, would you say that again?
So the notion of consent that creates authority, is that hypothetical consent based on good reasons people have? You have the notion of reasons there, or is it purely factual consent?
Purely factual, yeah. You could have really bad reasons, yeah.
All right, Thank you very much. Let's thank Kirk again.